This hearing is in regards to case number CFI 026-2022 before Justice Wayne Martin. The claimant is represented by BSA Ahmed bin Hazim and Associates LLP. Lead counsel is Mr. Kaylee Wright. The first defendant is a litigant in person and is represented by Mr. Yousef Hawash.
Thank you. Mr. Wright.
Yes, Your Honor. Can I confirm that you have a version, at least, of the hearing bundle, which I think runs?
Yes, I do. I do. Yes, I have the bundle, and I've read it. Thank you.
I'm grateful. And may I just check? Are you using case lines or a PDF just for referencing?
I'm using case lines, so
I'm grateful.
I'm using that version.
I don't have access to case lines. I'm working from a PDF, so I'll just try and make sure I give any references.
Give me the page number. That will be fine. Thank you.
I'm grateful. Can I also just confirm Your Honor has received a very short skeleton argument from me?
Yes, I've seen that. Thank you.
I'm grateful. Well, Your Honor will see that I represent the claim. This is a claim primarily, at least, about who is the director of the second defendant. That seems to be the main issue in dispute, if I can put it that way. It was expected by the claimant that this would be the final hearing, and I believe it was listed on that basis for a number of hours.
Yes.
On Friday afternoon, the claimant discovered that the defendant has actually filed a document. It's called Particulars of Defence, but it's obviously intended as a response document of some kind, and also appears to seek to bring some form of counterclaim or ancillary claim of the first defendant's own against the claimant. In those circumstances, it seems to the claimant it is unlikely that the court will be able to finally resolve this dispute today, not least because the defendant raises several factual issues, which, first of all, are not normally appropriate to be dealt with under Part 8 proceedings, and secondly, the first defendant, as I mentioned, appears to bring some form of counterclaim, which appears unlikely that the court could resolve today, and the claimant, if those matters are to be resolved, needs an opportunity to respond to them.
The other issue, Mr. Wright, is that I may have missed it in the bundle, but I've looked carefully through the bundle, and I can't see any evidence in support of the claimant's claim. There's a couple of documents, there's a claim form, but there's no witness statement.
I believe the order of Registrar Hanady provided that, and I'm just trying to stand up on page 44. I thought there was an order at some point that the particulars of claim would stand as evidence. I may be mistaken on that. That was certainly the claimant's intention, that the particulars of claim would stand as its evidence in support of the Part 8 proceeding. Yes, I'm not sure the order does specify that.
Yes.
That would have required some form of order in any event.
Yes. Well, there's nothing in the registrar's order. So the ordinary course, there would need to be a statement from the claimant, at least, setting out the matters upon which he relies to sustain the claim. And that doesn't seem to be there.
Yes, I mean, as I see the way the bundle's set up, certainly the Part 8 claim form, which is in Part C of the bundle on page 53, then has the particulars of claim behind it, as it were, as if standing as a witness statement. But I can see, looking at it now, it doesn't appear that there was a specific direction to that effect. So it would have required a court order of some form that the particulars of claim stand as evidence in the Part 8 proceedings. I accept that.
Right. Well, leaving that to what do you want me to do?
Well, Your Honor, it seems to me the appropriate course of action would be first to transfer the matter back to Part 7. It was transferred on the basis that it appeared there was no disputed facts. Now that doesn't appear to be the case anymore, and so, Your Honor, perhaps that deals with the issue you just raised, that there doesn't appear to be an order for a witness statement, that will no longer be required. Some consequential directions, it appears to me, are required. So first, well, perhaps it would be worth confirming with the first defendant that he is bringing a counterclaim, because that affects the consequential directions. But it appears to me that at least a reply in defence to counterclaim would need to be filed, and possibly, if so advised, a reply to defence to counterclaim by the first defendant. There will then need to be the normal directions for evidence, etc., and taking this matter to a final hearing. Your Honor, in the time available, it's not been possible to discuss directions with the first defendant, so it may be it's more appropriate simply to deal with them somewhat on the hoof during this hearing. Your Honour will also see that the final part of my skeleton talks about costs, but that can be perhaps dealt with at a later time in the hearing.
I think that's right. Well, Mr. Hawash, I assume you've heard all that. I don't know if you understood what we're talking about, but let me tell you that perhaps by way of context, if it assists, there are two different types of procedure available in the DIFC court. One is what's called the Part 7 procedure, which is suitable for cases in which there are contested facts. And so there are processes within the Part 7 procedure for the giving of the production of evidence with respect to those disputed facts. And this claim was commenced as a claim under Part 7. But when you didn't respond to the claim, it appeared to the claimant that there wasn't going to be any dispute of fact, and so it applied to transfer the proceeding from a Part 7 proceeding to a Part 8 proceeding, and that application was granted on the assumption that there would be no dispute of fact. And everybody was proceeding on the basis of that assumption until very recently when you filed your defence. And so it appears from that document that there are issues of fact that are contested. And so Mr. Wright tells me that in those circumstances, the best course would be for the case to go back to Part 7 and be dealt with in the appropriate procedure where there are disputes of fact. Now, do you have any comment on that proposal? Anything you'd like to say in relation to that?
I'm sorry. I'm sorry for my English is not like everybody here. So I just can't say what happened exactly. And then it's your decision, sir. I just all what happened. That's Mr. Marwan, which is the claimant. There is a contract was between me and him in October, and he doesn't implement this contract at all, and he doesn't do his part. And on top of that, when he wants to resign, there is a lot of things in this company. He doesn't do handover, and there is also money involved in this company. There is assets involved, and there is original contracts involved in this company. All those with him, which worth millions of dollars, and the company will lose it if he resign without hand over those things. And this was part of his commitment in the contract. So all what he want to do, he just want to escape from the company and keep the company with the debit without doing his part by implementing the contract and bringing the asset to the company and hand over the assets and hand over the technology which can bring money and which can keep the company make money. So this is in very simple way. And I'm sorry because I don't have lawyer. They keep us in very bad situation. We can even keep us like we cannot afford to hire a lawyer for that. Really, he did a lot. He did big damage for the whole group and for the whole companies, and he keep us in this situation. So,
right. Well, I take it from that, and I'm looking at the document that you filed.
Yes,
you want a counterclaim. So you want an order of the court that the claimant remains a director.
Yes.
Of the second defendant. Yes. And you want an order that you are not a director of the second defendant. Is that right?
Yes, that's right. Because I believe as per the law, the director should solve what he did. Yes, so he want to keep me on the front, and he want to escape with what he did before.
All right. Well, it's clear then that you do have a counterclaim. Do you have anything more to say about the question of whether I should direct that the matter go back to be dealt with as a Part 7 procedure? Do you want to? It's really just a procedural issue.
Sorry, sir. Sorry.
I explained to you before the difference between Part 7 procedure and a Part 8 procedure.
Yes.
Do you have anything to say about whether the case should go back under Part 7?
I believe it should go back to Part 7. Yes.
Yes. Right.
In the beginning, sorry, sir. I received the notification on the Part 7 Okay, and we read it, and we believe in the law of the DIFC that this will not happen. So that's why we doesn't respond on that one.
Yes.
And the court it reject this one, because it's very clear, sir. The DIFC will not put the shareholders and the assets and the money of the people will not accept like this behavior. I'm sorry for with all my requests.
Well, I understand. Well, I think if I might go back to Mr. Wright now, unless there's anything else you wish to say. No, you're okay if I go back to Mr. Wright. Well, Mr. Wright, it seems to me that the proper orders to make are that the matter be returned to Part 7, and that you put on a reply and defence to counterclaim. How long would you need to do that?
Not enormously long, Your Honour, but I would ask for perhaps 4 weeks.
4 weeks, yes, all right. So that would, I'll just get my preferred date. So let's look at 4 weeks' time. It will be the 31st of October.
Yes, thank you.
So 31st of October for reply and defence to counterclaim, and then Mr. Hawash,
Yes, sir.
You would then get an opportunity to respond to that document. How long would you need to respond? So Mr. Wright will respond to the document that you've put on, and then you need to respond to that. So how long would you need to respond to that?
It's okay, sir. Like I need 2 weeks is fine for me.
2 weeks, all right. So if you would respond then by the 14th of November.
Or the
Monday the 14th. 14th, Monday the 14th of November. And then, Mr. Wright, should we go? I don't know that we can go much further than that at this stage, can we? I think after that, we should go back and see the registrar for some more directions, case management directions.
Yes, Your Honour, I was thinking it may be better to formalise it that way rather than try and give directions on the hoof now. Yes.
Yes. I think it'd be better to wait and see where what the case looks like after the further process of pleadings. Now, do you want to say anything on the subject of costs?
Your Honour, sorry, is that to me or to Mr. Howard?
Yeah, sorry, Mr. Wright.
Yes, you'll have seen from my skeleton we do see a cost. Sorry, Your Honour, just before I do that, just one point which you raised earlier. I knew you had seen somewhere that we asked for the particulars to stand as written evidence. That is in our witness statement in support of the transfer. That's page 17 of the bundle. So it was something that was mentioned. I of course accept it's not explicit in the order that that's what should happen. Although the fact that it goes straight to evidence for the defendant does suggest perhaps that's what the registrar had in mind. But I just flagged that because it is a point that we had considered and had addressed, albeit not perhaps as fully as we ought to in terms of getting it in the order. Your Honour, what I say is until Friday morning, it appeared to us that this was that there was no substantive response from the first defendant other than an acknowledgement of service saying he intended to dispute the claim. In those circumstances, we prepared as if this was going to be a final hearing, and until Friday afternoon, that's what we were expecting it to be. It appears Mr. Hawash has filed a document which is called Particulars of Defence. It's still not clear to me when that was filed because the document is undated, and as I understand it, it doesn't appear on the portal. So not only is it a document we haven't seen, it's a document we couldn't have seen. It's a document that ought to have been filed and available on the portal. It's also a document which ought to have been served on us. I don't think there's any controversy that it hasn't been served on us, and so Mr. Hawash has not complied with the rules. That is itself, in my submission, reason to make a cost order, but that's particularly so given that we did actually remind Mr. Hawash of the requirements to serve on us. And Your Honour, I think I can turn up that email. Bear with me, sorry, I've just lost my reference. It's page 63 of the bundle. On the 19th of September, those instructing me wrote to Mr. Hawash saying that noting he filed an acknowledgement of service but not served it on us, noting Mr. Hawash's intention to defend the claim. And then it says, accordingly, as per DIFC Court Rule 826, if you wish to rely on written evidence, you are to serve the same on us and file it in the court portal. This has not been done, and you are urged to do so as a matter of urgency. As per GFC Court Rule 834, you may not rely on any written evidence not served and uploaded to the portal. And then recommends that Mr. Hawash get legal representation. So had this document been served on us in good time, and had we then appreciated that, firstly, Mr. Hawash does intend to defend the claim fully, secondly, that he raises factual issues, we would have had this sort of discussion much earlier. And rather than preparing for a contested hearing today, we would have prepared for, at most, a case management hearing, or more likely simply agreed directions and vacated this hearing entirely. So we say that the reason this hearing has gone ahead and has gone ahead the way it has, and not been as effective as it could have been in terms of progressing the case, is because of Mr. Hawash's failure to comply with the rules, and it's a failure that was known to him because we reminded him of this requirement very recently. So in those circumstances, we do seek a cost of the costs essentially thrown away of today.
Well, Mr. Wright, I'm afraid I'm against you, because my view is that the costs of today were always going to be thrown away because of the gap that I mentioned earlier. There's simply, even if Mr. Hawash hadn't done any of the things he did, I wouldn't have been able to grant judgment in your favour because of the lack of the evidence not filled by an order. So I think this was always going to be a waste of a day, frankly. So the options are, I think, either costs reserved or costs in the case. Which do you think would be preferable?
Well, cost reserve does leave a bit of flexibility in case matters appear different on a different day in the fullness of time. So I would submit cost reserve.
Right. Well, Mr. Hawash, I don't know if you followed all that, but an application was made for an order that you pay the costs of today's hearing. I haven't allowed that application. What I propose to do, unless you think otherwise, is simply reserve the costs of today to be dealt with on another occasion. Do you have any objection to that?
Sir, I believe the registrar here is with us and can hear us. I was trying to upload my defense on the time, and there is some troubles what happened in the on the portal, and we solved it. So that's why we late few days on our submission. Then later also the claimant also, he faced the same issue, and I can saw it because we are all communicating by emails. I saw that they faced the same issue what I had, that we don't have access to this case because the registrar he make it. So he took time to read my defense. So I believe it's not my mistake. I don't know.
I'm not suggesting it. All I'm suggesting is that we just stand over the issue of costs to be discussed at some later date.
Okay,
Is that okay?
It's fine, sir. It's fine, sir.
All right. Well, then the orders will be, Mr. Wright and Mr. Hawash, the orders will be that the matter will be remitted back to Part 7 to be dealt with in accordance with the Part 7 procedure. There'll be a direction that the claimant will put on a reply and defence to counterclaim no later than the 31st of October. There'll be a further direction that the defendant, and that's you, Mr. Hawash, you have to respond to that document no later than the 14th of November, and the costs of today's hearing will be reserved.
Okay.
Is there anything else?
Thank you, sir.
All right. Thank you both for your time. Thank you.
Thank you.
Goodbye.
Thank you.